The Justice Department is now appealing that Trump-appointed judge's decision to overturn the mask mandate on public transportation. In a brief statement, the DOJ said, in light of today's assessment by the CDC that an order requiring masking in the transportation corridor remains necessary to protect the public health, the department has filed a notice of appeal. For now, passengers will be able to continue traveling without masks. With us tonight, Professor Melissa Murray of NYU Law School. She was a law clerk for Sonia Sotomayor on the federal bench before her nomination to the Supreme Court. Great to see you. How is this all going to work? Map it out for us. What can we expect in the coming days and months?
So the appeal is going to be filed to the 11th Circuit, which is the intermediate appellate court that sits in Atlanta. From there, it can progress to the Supreme Court. It surely will progress to the Supreme Court. But here's the rub, Chris. This mask mandate was set to expire on May 3rd. So while this appeal is likely going on, we're going to be in a situation in these next couple of weeks while that appeal is happening where the mask mandate is actually going to expire. And so I think there's some strategy going on here at the DOJ. They did not immediately challenge this decision by Judge Mizell. They took a couple of days. They said they were waiting for the CDC's guidance. Now they filed the appeal. I think what's going on here is that they're waiting because they do actually want that mask mandate to expire, because if this appeal goes to the 11th Circuit and then on to the Supreme Court, it's unlikely to be reversed. This is a 6-3 conservative supermajority that has already expressed considerable skepticism for the CDC's authority to fight various aspects of this pandemic. The DOJ is also likely worried that this decision not only invalidates the mask mandate, it also seriously challenges the CDC's authority to respond to any public health crisis, whether now or in the future. It would be best for this decision to be entirely overruled, but that's unlikely. But if this mask mandate expires on May 3rd, as it will, while this appeal is pending, then the appellate court can send it back to the district court to vacate the underlying order, which is the closest the administration is likely to get to a reversal in these highly, highly partisan times.
Well, how big do you see the threat to the CDC and its authority? I mean, this is, yes, it's about the law, but it's about public health. COVID cases are rising nationally. That's one of the things DOJ was watching, one of the things the administration was watching.
I think that's exactly right. I mean, that is the tension here. We had a federal judge, not someone who is a scientist, not someone who's an epidemiologist making this decision, but it is completely consistent with what we have seen, not only from this court, from Judge Mizell's court, but also from the Supreme Court. We earlier saw the Supreme Court invalidate the eviction moratorium that the CDC issued. There is a broad assault on the entire apparatus of bureaucracy on the ground that these administrative agencies lack the authority to take these steps to ensure public safety, to ensure workplace safety. And so I think they are genuinely worried that a decision like this can then be copycatted by other courts and eventually be used to really hobble the CDC and other administrative agencies.
All right. There are also new developments in the January 6th investigation. The New York Times is reporting tonight that Alex Jones is looking for an immunity deal to detail his role in the rally before the attack on the Capitol. What kinds of things will DOJ look at in deciding immunity, and how important could this be for the investigation?
Well, first, it's worth noting that Alex Jones has had a rough couple of days in the courts, and he's already seen his organizations declare bankruptcy this week. Earlier, there was the issue of the defamation suit brought by the Sandy Hook plaintiffs where he did not present a case in court, and they got a judgment by default. Now he's in this position to provide information to the Department of Justice. Whether or not he will be granted immunity really depends on the nature and quality of the information that he is able to provide. He previously testified before the January 6th special committee, and he said that during that particular testimony, he pled the fifth multiple times. He can't do that and expect to get immunity. So he really has to give up something, and it has to be substantive.
Also tonight from the Times, some members on the January 6th committee say they're considering rewriting the Insurrection Act. That's, of course, the 1807 law that gives the president pretty broad authority to deploy the military within the U.S. to respond to a rebellion. Let me read for you how the Times sums up the arguments. Proponents envision a doomsday scenario in which a rogue future president might try to use the military to stoke rather than put down an insurrection or to abuse protesters. But skeptics worry about depriving a president of the power to quickly deploy armed troops in the event of an uprising, as presidents did during the Civil War and the Civil Rights era. What's your take on this debate?
I mean, I think this is all part of the long hangover from the 4 years of the Trump administration. We know that former President Trump threatened to use the Insurrection Act to put down civil protesters in the wake of the George Floyd protests in 2020. We know that the Insurrection Act has been used multiple times throughout our history to deal with uprisings, but also to facilitate the exercise of civil rights. As you note, LBJ deployed the Insurrection Act to send the National Guard to Selma. JFK used the National Guard to integrate schools. And so this is an important act. But again, the fear is it's not going to be used to facilitate the exercise of rights or to preserve the peace, but rather will be used by, again, a rogue president for purposes that are more nefarious. And so the question of rewriting this, I think, is something that they are definitely thinking about. But others worry that if you hobble the president, require that the president consult with Congress before deploying the Insurrection Act, then you're really depriving a president of the authority to respond swiftly and expeditiously to emergency situations. But again, that was always the fear with the former president, that he would respond too expeditiously and without a lot of consultation.